Adjournment request, if any, from item number 1 to 8.
Wait, please, Your Lordship. Lordship, in item number 5, my lord, we are praying for a week's time, my lord. In fact, my lord, the PWD has already filed its affidavit. My lord, we would require some time to file our rejoinder to that. Well, this is regarding the Deeper Bill matter, my lords. Okay.
Hello,
10
for the,
days.
for the
10 days.
Deputy Commissioner, our affidavit is ready. We are filing it today. I'll
10
send.
days. 10 days.
Grateful, my lord. Highly obliged.
From item number 9 to 16. From item number 17 to 24.
May I please? I'm on behalf of Mr. P.K. Roy Sudhir Miller regarding item number 23, my lord.
26,
23.
23.
One
Yeah.
of the relative of Mr. P.K. Roy Sudhir Miller is expired. That is why he has not come today, my lord.
Urgent. 10 days.
Sir, 2 weeks, my lord.
Have you informed the other side?
Lordship, please. Obviously.
From item number 26 to 36. Adjournment request.
May I please, Your Honor? I beg to mention item number 34 of daily list, Your Honor. Your Honor, kindly matter may be adjourned for the day, Your Honor.
Urgent. 10 days.
34.
Yes.
Any other request?
Yes, I beg to mention item number 45, 46, and 47, madam.
Yeah.
Madam, this matter will kindly refer for the day, madam, and fix refer for the day, madam, and fix a date in August, madam,
Why?
on last part.
Why?
There's some issues that we have to prepare it properly, madam. If understand, not
After a
today,
week.
madam. We have taken the concept of the other side also,
After a week.
after it, madam.
May I please, Your Lordship?
Obli-
I beg to mention item number 44, Lordship. In this matter, last occasion, Your Lordship has directed us to produce the original joint verification report regarding Mizoram matter, Lordship,
Original joint.
verification report. But they have communicated us, they pay for some time that till date, they could not trace out the joint verification report. But therefore, I pay 2 weeks time, Lordship.
2 weeks time.
Yes. I have informed all the respected parties.
Yes.
Others. Another prayer in item number 35, we have filed a affidavit in opposition, Lordship, on 9. That may be called for to the record. Obliged.
May I please, Lordship? Lordship, I beg to mention item number 42. Lordship, petitioner counsel is in bereavement, Lordship. Lordship may kindly grant 2 weeks time.
Then this 43 is also connected to it. 42 and 43 are connected matters.
Yes, Lordship.
Who is for the 40? Who is appearing in 43?
As Sinha, Lordship.
Have you informed him?
Yes, Lordship.
Have you informed the other counsel in the appearing in the other petition?
Yes, Lordship.
Okay. 2 weeks. Yes.
Obliged.
Lord, I will be allowed to move an urgent writ appeal tomorrow, my lord.
Why?
Lord, the urgency, this is with regard to, my lord, 3 students of IIT, final year students. My lord, they were expelled pertaining to some incident wherein we are not at all involved. And that expulsion was challenged before the learned single judge. In the meantime, they got their job also, since they are final year students. And, my lord, if the expulsion is not, my lord, interfered, they'll lose their job, my lord.
The learned single judge refused to interfere in it.
Yes, sir. The learned single judge has refused to interfere. Also recorded a finding that there was gross violation of principles of natural justice. But despite that, my lord, the expulsion was not interfered. Highly obliged.
Daily list for orders item 1.
May I please, your lordship? My lord, here in the case, my lord, as per your lordship's order dated, my lord, 24/5/24, my lord. They have filed affidavit, but does not indicate the calculation method, my lord. Your lordship has specifically directed them, my lord,
The state is directed to file and regarding calculation of the arrears have been paid. Yeah, ma'am.
Well, Lordship, I have filed the affidavit that Lordship, which has been enhanced by the authority Lordship as per notification, and Honorable Supreme Court has directed. He is claiming 40 months arrear salary, Lordship, that we already denied by earlier affidavit, Lordship. He was not in service on that period, Lordship. Earlier affidavit kindly gone through, Lordship.
You file counter to it, whatever the calculation is, they are not.
They have not given any
calculation.
calculation, my lord. Against that, we have filed our reply also. But
Can
your
we place
lordship
it
has,
for admission? List for admission after 10 days. 2 weeks. 2 weeks.
Item 2 and 3.
Well, in item number 2, we have filed an affidavit on Friday. Well, it is not on record. And well, the same affidavit will also cover item 3. Well, I'll serve a copy to my learned friend. Kindly pick it up on Friday or Monday. Well. We filed on Friday, well, last Friday. So I can copy to Paisa.
Legal and Mr. Dinath has submitted that he has already filed additional affidavit pursuant to the direction given by this court on 1/8/2024 in PIL. So, 3/2022.
Gotcha.
It is submitted that the said affidavit covers the issue raised by the petitioner in writ petition number 239/2024 also. Stop. The affidavit, additional affidavit is not on record. The same be placed on record and list this matter on Friday for admission.
I'll use it.
Yeah, you supply the copy of that.
Yes,
affidavit.
I'll serve. I'll serve.
Item 4.
Questions to the last order, my lord, they have to file status report
My lord, we
regarding,
have got on a status report, we'll be filing it in the course of the day, my lord.
regarding eviction that he, elephant human conflict, my lord, in Goalpara district.
Okay, Mr. D. Gogoi, then counsel appearing for the forest department has submitted that the affidavit would be filed during the course of the day.
Fine.
So stop. List on Tuesday,
All right.
along with the status report. Affidavit along with the status.
My lord.
report.
Well,
Item 6.
Your Honor, a new address of respondent number 5 has collected and we will file amended cost title. So kindly pass over the matter for the day.
Okay, and counsel appearing for the appellant has submitted that the fresh address of the respondent number 5 would be furnished by filing an amended cost title during the course of the day. When you are going to file this.
Tomorrow,
amended-
day after tomorrow, Lordship.
Within a period of 3 days. To stop, list this matter of 2 weeks.
All right.
Item 7.
May I please the Lordship? This my lord. Service notice is issued, my lord. We have taken the service of Lordship, but that is.
Yes,
I appear on behalf of the respondent number 5, and I put my appearance on behalf of respondent number 5 today, my lord. I earlier appeared on behalf of respondent number 7. So I'll file my response, my lord, and lordship will grant me a week or 10 days time.
okay, Mr. So and so put in evidence on behalf of the respondent number 5. What about respondent number 4? What about respondent number 4?
Let me take the step upon the respondent 4. By
Yeah.
Dosti also, but report is not yet been collected, Lordship. Upon the respondent 4, we have taken a register as well as the Dasti, my lord. But
That-
Dasti is not yet been received, my lord.
Received. Okay. Mr. So and so put in appearance on behalf of the respondent number 5. However, the notices issued through the respondent number 4 has not been served. Has not been received till date. Let notices be awaited, let the notice of respondent number 4 be awaited for 2 more weeks. In the meantime, amended cost title filed by the, filed on behalf of the petitioners be taken on record.
Hello.
Item 8,
Respondent
May I
number 4 and 5 has not been served.
My lords had instructed me to appear, my lords. I'm the standing counsel for the APDCL, my lords.
Respondent number 4 and 5.
All the respondents, in fact, my lords. I'll be filing my,
Yes, what do you want now?
my lords, I'm praying for 2 weeks' time, my lords. I've instructed my clients to furnish a report on the issue, my lords. We are taken by surprise because, my lords, we have not even served a copy of the PIL. And when the matter was disposed of, my lords, no one had appeared on behalf of the APDCL, my lords.
When it was disposed of?
On 18/10/2023, my lords. The order is at, starts at page 16.
So whether you have decided that representation or not?
My lords, I've instructed, my lords. The report is being prepared, my lords. I'm praying for 2 weeks' time. Furnish the same.
Okay, Mr. So put in appearance on behalf of all the respondents. Okay, Mr. B. Chaudhary.
My lords.
You are B. Chaudhary.
My lords.
Mr. B. Chaudhary, counsel appearing for all the respondents, place some time to file status report. List up 2 weeks.
I'm deeply.
item 9,
Thank you, Lordship. Lordship, the last discussion I have taken is step, Lordship, on 24/5/2024, Lordship, the second time step, Lordship, regarding the IA for corner from the delay, Lordship, 200, 12.
That still the notices of respondent number 3, 2, 6, and 7 has not been served.
Yes, I have taken already step, Lordship.
But we have already awaited once. You take fresh steps for notice upon the respondent number this
29 July.
2, 3, 6, and 7.
Lordship, notice waited, Lordship.
Okay, await return of notices of the answered respondents for 3 more weeks.
Yes. Master Lordship.
item 10 and 11,
May it please your Lordship. Lordship, on the last day, the respondent number 3, Lordship, they have submitted their objection to our interlocutory application, Lordship. They have basically raised their objection on 2 points that we have filed our application under a wrong provision, and Lordship, about the candidature, that the applicant has not submitted his candidature at the time of the provincialization of the college, Lordship. So, Lordship, I would like to give my reply for both the objection, and firstly, I would go to the candidature part. So, Lordship, the Uttar Kampi College who received its provincialization order, Lordship, at 21/2014 with effect from 1/1/2013, Lordship. And Lordship, at that time, the respondent number 11 of in the
You want to file counter to that affidavit?
no, Lordship.
You don't need.
Lordship, the respondent number 11 in our
Just,
retaking.
just. Make this appointment orders subject to the decision of the writ petition. Whatever the orders they are passing during the pendency of this writ appeal,
Yes, Lordship.
will make those orders subject to the decision of the writ appeal.
Lordship, actually what happens, when the governing body of the college and the petitioner lordship, they come to know about the malpractice done by the former principal, respondent number 11, then lordship, they came before this honorable court. But lordship, by this time, in the year of 2014, the respondent number 11 already retired, superintended from his service, lordship.
Which is that order, the 6/7/2024?
6/7. Sorry, lordship.
Which is that order 6/7/2024, which you want to, which you have assailed in this application? What is this order?
17/3, my lordship.
Lordship, we have challenged the 17/3/2023 order.
And in
it's
this
a-
application, your
Yes.
prayer is,
Yes, lordship.
hence the impugned office notification dated 6/7/2024 issued by the respondent number 3, particularly in respect of so and so, be quashed and set aside. Where is that order?
Lordship, annexure. Lordship, annexure A, lordship. Order, no. That is in lordship, annexure C, lordship, page number 33. Lordship, the director has knowledge about the repetition, appeal filed by us, lordship, and we have already served the notice to them. But despite such knowledge, lordship, they issued this office, notification, lordship. And lordship, my college is in serial number 10 in that notification, lordship. Lordship, my prayer is that kindly set aside and was this notification, but lordship, not wholly, but partly. Just on the part of the Uttar Complete College. As lordship, we have filed 2 of writ appeal regarding this matter before this honorable court, lordship. And Lordship, in that state is this honorable court does not interfere, Lordship, then my grievances will be never mitigated, Lordship.
The matter comes upon for consideration of the IA number so and so. We deem it appropriate to hear this IA along with the writ appeal number 420/2023. Hence, the writ appeal be listed for the writ appeal number 420/2023 be listed after a week. We'll consider your application at the time of admission.
But Lordship, by that time, if a principal is
That is
appointed
of
to that
6/7/2024.
post, Lordship,
More than a month is already passed. We'll see to it.
then Lordship, status quo may be passed for the
Yeah.
week, Lordship.
Here and then only.
Item 12.
Obliged.
Yes, you are appearing, Mr.
I'm appealing.
They moved an application for substitution of Ajay Tiwari.
Lordship.
You are appealing for him?
No, my lord. In fact, my lord, the respondent number 1 and 2, for whom I appear, so both of them have retired, my lord.
Both of them have retired.
Two retired and one is not in post, my lord.
One is not in post.
Not in post. And in place of one, my lord, they have filed the IA to bring the new officer, my lord.
Now, so far, Lordship, the contender number 2 is concerned, the post of secretary hasn't been filled up as yet.
Right.
But they are functioning with a additional secretary. So Lordship, I may be permitted to bring the additional secretary on record by way of subsequent IA.
Okay, you move that application, will decide both the applications together.
Lordship.
After 2 weeks.
Lordship.
For admission, item 13.
May I please? During the pendency of this case, the petitioner has preferred another writ petition for the honorable single judge challenging the impugn opinion, that in that case, my notice is already issued by this honorable single judge.
So now this has become infectious.
Yes, Your Lordship, but one thing is there, is the interim protection is there with regard to the appointment of the petitioner. Already petitioner has been appointed. Her appointment is subject to outcome of this writ petition has been there. So, my lord, Your Lordship will kindly observe that.
That you get this observation in that writ petition. Sir. How in this?
Your Lordship's observation is there.
Then a concept of the petitioner has submitted that during the pendency of this petition. The petitioner has already preferred another writ petition number 3809/2024. Writ petition number 3809/2024. It is submitted that in view of the fact that the appellant and the petitioner has already preferred writ petition and has already preferred another writ petition which is pending consideration. He does not want to press this petition at this stage. He wants to withdraw this writ petition, hence dismissed as withdrawn. It is made clear that dismissal of the writ petition on withdrawal will not affect the merits of the writ petition, another writ petition filed by the petitioner.
Item 14.
This is appeal preferred by the state revenue. Lordship, on last occasion, Lordship directed me to produce the judgment passed by the Calcutta High Court. I got the copy, but Lordship, I was informed by the department that they preferred SLP, but the status of the SLP is not known to me.
Adjourn for 2 weeks.
Not. Another 2 appeals are there. Lordship, on last occasion directed the both the appeal be listed along.
Those listed and not been listed.
Yes. Custom reference
Yes,
number.
ma'am.
My lord, otherwise the valuation of the consignment in question is less than 1 crore, my lord, in this petition, my lord, in this matter, my lord. So there is a direction, my lord.
There is an exception to that, Lordship. If question of law is involved, then Question of
Now we have to decide whether any question of law is
My
involved or not.
Yes, Lordship, that's why it directed me to produce the judgment of the Calcutta High Court.
Order,
And this Calcutta order,
order passed by the Appellate Tribunal, Calcutta, my lord, and the basis of the order is a notification, my lord. I have provided the notification also, my lord. Where, my lord? Monetary limit for the department to file appeal before High Court is 1 crore, my lord. So what is that?
against this order, you have preferred SLP.
Yes, Lordship, I have informed the department, but the status is not known to me. Whether it is dismissed or allowed, pending.
So by what time you will get the,
Day after tomorrow.
after a week, along with
Right.
this custom references? Along with,
Custom appeal number 1 of 24. And another is yet to be numbered.
appeal, why appeal?
Custom reference. my lord.
Custom reference, sir.
Custom reference number
1 of 24.
1 of 24.
We have to check. Okay.
Item 15.
15, 16, 17 are similar, arising out of the common judgment.
15, 16, 17.
There are 7 appeals, 3 has not been listed today. Initially, there was a delay in preparing appeal that has been come down in 4 appeals. Lordship.
Fine.
Lordship, here. Lordship, may take together all the appeals.
This along with.
I'll provide the number.
Supply this.
Yes. Item 18.
Wait. My lord, the review was dismissed. Again that, now of course, we are challenging both the orders. Now, my lord, if your lordship will kindly come to page number 57.
Just a minute. Just a minute.
Yes. কিন্তু চেঞ্জ করা নাই pending up to maybe impact. Besides, then it's a separate copy. Yes. Yeah. Lord, what had happened in this case, the writ petition was withdrawn. With the,
Not press.
not pressed with the liberty to approach the appropriate forum. Lord, in fact, we have already approached. That is our case.
To whom?
To the appropriate authority. Please come to section 1, page 125. Page 125.
Yeah, Mr. Chaudhary,
Yes.
just 1 minute. Your client withdrew or did not press the original writ petition to avail alternative remedy.
Yes.
That alternative remedy was to take the plea before the authority designed under the contract.
Yes.
That's correct.
Yes.
Now, when that process was going on, they did not decide your plea.
Yeah.
Instead, they issued a fresh contract.
Yes.
So you want now the review of the order.
No, what I want is, my lord, now the work has already been allotted to somebody else. I'm not on that. But my lord, my security will be forfeited for it.
So that's a fresh cause of action.
My lord,
That's a fresh cause of action for two reasons.
No.
First of all, just for two. The order in the review petition is not appealable. The law, you will know it.
no, basically I'm challenging the original order.
That is what is wrong with that order? You have withdrawn it.
No, that is a wrong. That's what I want to show. Please permit me to place my case.
Yeah.
Please come to page 125.
Yes.
That is wrong. The lawyer committed an error. He should not have. And there was no authority, plus he has already availed that remedy. Page 24, clause 24.
Yes.
If any dispute or difference of any kind whatsoever shall arise in connection or with arising out of this contract or execution of the work or maintenance of the work thereunder, whether before its commencement or during the progress of the work or after termination, abandonment, etc., it shall in the first instance be referred for settlement to competent authority within 45 days of arising of the dispute. My lord, we have done this. What is the question of availing alternative remedy? Please come to page 67. In the meantime, my contract was terminated, my lord, without disposing of my. Then I filed this on 23/8/23. Chief engineer is the competent authority. With reference to notice regarding PMJSOI project, I wish to inform you that after receiving the notice to proceed, we began mobilization effort. However, monsoon onset and subsequent flooding have submerged the project area. Safety dictates awaiting for the flood waters to recede before work begins, and same was intimated to you by my letter under serial 4. In response to the executive engineer's direction by letter under reference at serial number 5, I submitted a revised work program by my letter under reference at serial so. Despite knowing this, I challenges the executive engineer concerned, deemed our submission unacceptable without explaining any reason. It is pertinent to mention herein that no field official advised me about how to execute the work in the present ground condition. Regrettably, a termination notice was issued without any prior discussion notice. The contract allows 12-month time for completion of the project, which will be due in May 24, and I commit to honor this timeline. Please understand revised work importance tailored for safety and success despite challenges. We are dedicated to the project, appreciating its impact on our so-and-so. Your reconsideration of the termination notice would greatly aid our shared goals. In view of the above facts, you are requested kindly to use your good office to reconsider the decision of termination. This is under clause 24, my lord. So where is the question of I again making an approach?
What is the order of the learned single judge?
Order of the learned single judge in the initial proceeding is?
Mr. Day, learned counsel for the petitioner.
Yes,
has
my lord, the
submitted
order of the learned single judge, page 74.
Para number 3.
Yes,
Mr. Day, learned
yes.
counsel for the petitioner has submitted will not be pressing this petition
Hmm.
in order to avail appropriate remedy available.
So my lord, he was,
That appropriate remedy just and subsequently, immediately after passing of this order by this court, you served a notice of the
yeah, my lord, that was done. No, no, what I'm
means,
saying,
means the petitioner was having an intention to challenge the whatever action before the civil court. That you have availed the appropriate remedy, you have not said this before the redressal grievances committed.
no, my lord, my humble submission is very simple.
Yeah,
Now, lordship will kindly see the work to commence, that notice was given on 4/5/23.
yeah,
And my completion period is 12 months,
Fine.
May 2024.
Fine.
My lord, and we all know even now we are in August. Is any construction activities possible in Assam? Because of the condition? No. During this period, my lord, this termination was resorted to. And my lord, the area where I was supposed to undertake the road construction, it was already under water, my lord. So I said, when that second notice was issued, I said, I'll keep my words, I'll complete the project by May 24th. So what was that urgency to revoke it in July, my lord? Achha, now let me come to your lordship's query. So your lordship's query is
yes.
That I have issued a notice under section 80 CBC, that is a fact. That we have brought on record.
Seeking damages
No.
and many.
Now question is, my lord, this submission of the learned council was wrong. For council's wrong, my lord, it is a division bench judgment.
Which submission of the land?
This Mr. Day learned counsel has submitted that the petitioner will not pay. He never had the instruction from the client. I have taken a specific ground.
But what action this?
No, my lord, this not, no,
the
every
petitioner
time we
has
cannot.
taken- No, sir, it is supposed to. If you are claiming so vehemently that the advocate has not, no consent was.
My
with
lord,
the
in
advocate
fact,
and
we have
then
taken a
certainly you
ground.
would have moved to bar
Okay.
council or somewhere.
Lordship will kindly come to para 18 at page 94.
Yes.
In our review petition, what we have said.
Yes.
In a review petition, para 17 at page 96.
Yes.
That the petitioner begs to state that the petitioner did not give any instruction to the counsel representing petitioner for not pressing the said writ petition in order to avail appropriate remedy available to the petitioner under the law. It is an admitted fact that the petitioner has already approached the competent authority, that is respondent number 3 as per tender condition, by way of a written application dated 23/23 for redressal of his grievances. Therefore, apparently no question arises for the petitioner to instruct his counsel to withdraw the said petition to avail the appropriate remedy. In fact, in the humble submission of the petitioner, the counsel representing the petitioner erred in law and in fact in not pressing the writ petition. It is stated that in the process, the cause of the petitioner has been seriously prejudiced. Every time, my lord, when we say the lawyer was wrong, it does not mean we'll have to go to the bar council, my lord. That we don't mean. My lord, in fact, there is a judgment of our division bench judgment of our High Court,
Yes.
of which Honorable Justice Shyam was a member, where a wrong submission by the lawyer was condoned and a review was allowed.
So we would have,
Yes, kindly have this.
we would have considered this argument, sir.
Well, it's a very,
Had this review petition was filed by the same counsel. That since I was not having any consent from that person, and therefore now I am moving this. Certainly, we would have considered.
that is a possible view, my lord. I am saying not no to it. Kindly come to page 101. Para 22. Para 22 of the judgment.
Of the learned single judge?
No, my lord, the judgment which I have given.
Okay,
just
okay, fine.
More or less in a similar fact situation, a division bench of this honorable court, my lord, had taken this view.
Yes.
A perusal of the judgment under review goes to show that the learned single judge had issued a direction for regularization of the services of the contractual teachers without subjecting them to TAT, which according to the review petitioner was impermissible under the rules. The state does not disown the submission made by the departmental counsel, but contends that the same was a mistake. Having regard to the law laid down by the Supreme Court in the case of BCCI, we are of the opinion that bona fide concession made by litigant or its counsel that subsequently turns out to be legally untenable can be a valid ground for reviewing an order if it can be shown that such concession was founded on a mistake of fact or law and was the sole basis for the court order terminating the list. Of which my Justice Shuman Sham was a party to this judgment, my lord.
In fact, he was the author of the.
My lord, here is a simple. My lord, all that I am saying is, let the authority consider my representation, then my lord law will follow it.
No, this review petition will grant you a liberty, another liberty to file a representation, but not in this petition.
Huh?
Mr.
No, my representation is pending at page 67.
Mr. Chaudhary, just a minute. The contract has now been awarded.
Yes, yes.
Correct.
Correct.
Now, you can't set the clock back.
No.
Forget legalities. You can't get this contract.
No, that's not prior either.
Now, the only question is, was it terminated validly? If yes, you don't get any remedial measure. If not, the remedy lies within the four corners of the contract agreement itself. So that's the only live issue which survives.
Correct.
And that has a direct, it impinges upon the plea of the Department of Risk and Cost. Correct. So these are two, qua the petitioner appellant, these are the two live
issues.
These issues cannot be decided in the writ petition. This is number one. Therefore, the remedy, we are not here to advise. You are a very eminent counsel, but remedy you are seeking might actually invite more trouble.
No, my lord. The remedy which I am seeking is that lordship should remand this matter to the single judge to decide the case on merit, nothing else.
No, there is arbitration clause.
My lord.
There is an arbitration clause.
No, my lord, that I have already done. That they have not done anything. I think lordship, maybe I have not been clear to yourself. Under this scheme, under the agreement, first approach has to be made to the competent authority against the termination, which I have made. The learned counsel who represented the petitioner on the earlier occasion did not bring it to the notice of the Honorable Court. Therefore, on his submission, this matter was closed. And that was a bona fide thing, my lord. We are not imputing anything on that. All that I am saying is, learned single judge to decide my case, or lordships will direct the authority.
What is the decision you are seeking in the writ court? Writ petition.
Writ petition, I challenge the termination. Now kindly see, this page 67, they can dispose this of. Page 67 is the appeal which I filed in terms of clause 24. That they should decide.
Close for orders.
Yes. No, Milord will kindly take note of that. My only humble submission is, page 67 appeal is pending. That they have not passed any order on that.
67.
Page 67, against the termination, this was my thing. And this is what is provided by clause 24.
So why don't you seek remedy with regard to that?
I'm saying that only. Alternatively, I said either matters should be remanded to the single judge to hear on merit or to dispose of this, a direction for disposal of this. That's my prayer, Milord.
Close for orders.
Item 19.
Yeah, please, with lordship permission, may I pray for withdrawal of this matter, lordship?
Withdrawal.
Withdrawal, my
No liberty.
No, I'm not praying for any liberty, lordship.
You are having proper instructions from your client?
Yes, my lord, yes.
Are you sure?
Sure, my lord.
Again, he'll come and say, I've never instructed the council to withdraw this.
My lord, I have proper instruction, lordship.
Wants to withdraw. On learned council for the appellant on instructions. I submitted that he wants to withdraw this writ appeal, dismissed as withdrawn.
Give his name, no? Give his name. Yo.
Yes.
Highly obliged, lordship.
Item 20.
Procedural. Okay. Well, in this case, sorry, in this case, they have filed an affidavit in opposition, but nothing has been stated with regard to the validity of this act.
That is their,
Yeah.
that is their strength. They have not
That-
said anything anywhere about the validity.
No,
Consider it. By this petition, the petitioner has challenged the validity of the Assam Inland Water Transport Regulatory Authority Act 2018, particularly the provision of section 14(1)(k) of the above act. Full stop. Taking into consideration the fact that the validity of the act is under challenge, we deem it appropriate to issue notice to the Advocate General of the state of Assam. Full stop. Copy of the writ petition be supplied to Mr. Advocate General by the counsel for the petitioner within a period of 2 weeks. This matter for hearing and admit. No need to issue notice as respective respondents are already represented through their concept. List for hearing in due course after showing, reflecting the name of learned Advocate General of State of Assam.
Item 21.
May it please the Lordship. Well, I'm appearing for response number 4, Lordship.
Yeah.
I'm going to file my affidavit today, Lordship. I have already entrusted my.
Prayer was made on the earlier occasion also.
No, I'm going to file it today, Lordship.
Today,
Yes, sir.
Nikhil and counsel appearing for the respondent number 4 has submitted that counters to the writ appeal would be filed during the course of the day. So stop copy of the counter be supplied to the counsel for the appellant. This writ appeal when
Lordship may admit this appeal and fix for hearing, Lordship, on next
it is already admitted,
not admitted.
see to it whether it was admission or not. 2 weeks.
Obliged.
Item 22.
May I please your lordships, in this matter, lordship ADC is praying for some more time to trace out the record as per affidavit filed by the appellant lordship.
How much time?
2 weeks, lordship.
Ma'am,
Already one record has been produced, lordship. But
25/6/2024, the order was there, then again we granted you time on 22nd of July.
lordship, no, already one record has been produced, lordship. As per petitioner, this record is not proper record, lordship. Therefore, he filed affidavit and I praying for some time to trace out that record, lordship.
Mrs. R.B. Bohra, learned government advocate Assam, has submitted that the record from the office of the Deputy Commissioner Kamru Metro is still not received. He says that as per she says that the record is being the record is still not traced out and there is likelihood that would be traced out within a period of 2 weeks. Just after 2 weeks.
Interim order. What's its interim order passed earlier?
Interim order, if any, to continue till next.
High level.
4 weeks, 4 weeks, 4 weeks.
Item 24 and 25.
Wait to the lot. My lord, if lordship takes up item number 25, same thing, 25, if my lord takes up for a moment, my lord.
25.
25.
Last occasion, we have.
Exactly,
some
exactly.
observations.
Exactly, my lord.
Oh,
But we have filed the affidavit. But I have two things against me. I'm not recalling the back part. My lord. The first thing is on my age part. On my age part, although I had adduced documents to show, lordship was pleased to put a query as to whether I am the only person on the planet having those plans. Exactly, we had
No, I didn't.
given a bank details, PAN card, everything, Aadhaar card, nothing more. Whatever we had to show that my father is this, etc. Nothing, because the education certificate does not reflect so.
Where is that document which you have annexed on the last day?
We have given them the affidavit we are filing, you know.
Affidavit, the page, a page.
That will be 132 onwards. That's the affidavit, and 135 onwards is the mark sheet.
130
135 would be the mark sheet. No?
in this second report.
Second writ petition, actually. Then would follow the passbook. That thing is there. Then will not the electoral card. Aadhaar card, PAN card, etc. My lord.
Mr. Majumdar, these documents are admitted by you. You don't know.
Government record, file.
Huh?
It's a government record, I can have them verified from the official record. What's this,
The Aadhaar card,
Voter
PAN
card,
card,
PAN card,
passport,
Aadhaar card,
passbook, etc. But these are what they had. Even the lady was in the last occasion when she had to go home. Say, aged lady, I can get her on the court also next occasion. My lord, if lordship pleases me.
Court here.
Yes, yes, yes.
So why should we are not supposed to.
Otherwise, my lord.
No, we are not supposed.
No, I was more anxious, my lord, so far as the educational qualification is concerned. Age more or less is covered. No problem.
Actually, after a week. After a week.
Right.
Mr. Mazumdar, you also try to ascertain. Documents.
Item 26.
May it please your lordship, the engaged counsel is on legs. Can it be taken off after some time?
Also for the time.
Item 27.
Notice was served, I replied not filed, my lord. Impugn order is page 61, my lord.
Who is appearing?
My lord.
Who is appearing for that? And respondent number 3 and 4? Requirement of any counter you want to file counter? And what about you?
On my side.
There is not need. Legal and counsel appearing for the respondent number 3. You are for respondent number 4. You want to file a counter? Counsel appearing for the respondent number 4. Please for and granted time to file counter to the writ of appeal. This so and so on.
Item 28.
Malab, this item 28 may be taken after some time, Malab. Senior counsel is on legs, Malab.
28.
Yes.
Okay, pass for the time.
Malab.
All of us.
Item number 29 to 32.
For my lord's direction, we have filed affidavit in opposition on 8 lawsuit. It is not in the record lawsuit. 8
We have received lordship. They have not received partial lordship. In my case, I have received. I have not received.
In respect of lordship WBC 2303 item number 29, I have filed lordship.
Okay, then counsel appearing for the respondent number?
All the respondent in respect to item
All the
number.
respondent has submitted that counter to the petition has already been filed. Stop. However, the said counter is not available on record. However, this said counter in affidavit is not available on record. Registry is directed to this the same along with this writ petition.
2303 lordship.
Along with this writ petition means?
Lordship.
Yes, lordship, that is item 29. They have filed.
Along with the item writ petition number 2303 of 2024. This matter after 2 weeks. In the meantime, if the petitioner wants to file any counter to the rejoinder to the affidavit filed on behalf of the state, they may do so.
Lordship. Deeply appreciate.
Lordship, in item number 32, we haven't received a reply.
Yes, Mr. I think so. The provisions of the validity of the some act is under challenge.
Lordship.
That one affidavit would sufficient for that. Supply the copy of that affidavit. Please.
Obliged.
Item 33.
Your lordship, the notice has been issued on the last occasion, but the reply has not been filed yet.
1, 2, 4, 5, and 6.
Lordship, I am appearing for, I pray for some more time, Lordship.
Why?
Lordship, I have not received the instructions, Lordship. Pray for some more time.
Yeah, I'm paying for record number 3. Office is not been served upon.
Office?
Extra copies is not been served upon. That's one number 3.
Extra copies. Ask her, she'll provide you the extra
We've been
copies.
following up, Lordship, but it's not following. We've been following up, but not following.
Supply me a copy of the written petition.
Oh, my sublight knowledge.
लिखिए. Land Council appearing for the respondent number 1, 2, 4, 5, and 6.
Oh, 1, 2, 4, and 5.
1, 2, 4, and 5. Place some more time to file counter to the writ petition. In the meantime, counsel for the petitioner may supply copy of the writ petition to respondent number 3 within a period of when? Today?
So, yes.
During the course of the day. The respondent number 3 may also file counter to the writ petition if desired so. This after 4 weeks.
Okay.
Item 35.
Lordship, in this case, I have filed affidavit in opposition, Lordship, against the additional affidavit. So matter may be taken up, Lordship, any other day, Lordship. Tomorrow, Lordship.
Not tomorrow. Affidavit in opposition on behalf of respondent number 2, 3, 4, and 5.
No, Lordship, actually, yes, Lordship, 2, 3, 4, and 5.
That is there. Only at the request of Land Council appearing for the respondent number 2, 3, 4, and 5. List this matter after 3 weeks.
Item 26.
My lord, item 36 may be listed after some time. He is on leg. My senior is on leg.
P6.
After some.
We are at the. This is already concluded.
Director of Petitioner like this, education. Rules. Yes.
He's on leg, my senior. After some time. It may.
Supplementary list, item 49.
My lord.
Yes.
We have challenged before the learned single judge, my lord. A decision rendered by the learned industrial tribunal, wherein the learned tribunal has decided that the domestic inquiry is not valid. After the reference, we filed an application for deciding the issue of domestic inquiry as a preliminary issue. That was decided against us. We are before this honorable single judge under Article 226. Honorable single judge on a preliminary point that basing upon a judgment of the Honorable Supreme Court in a copper engineering case, saying that it is not amenable to writ jurisdiction. So the matter is to be decided in the final award. So for the domestic validity of the domestic inquiry. Now, my lord, our respectful submission before the learned single judge was that the copper engineering case we distinguished. So for the instant matter is concerned, the learned tribunal has exceeded its limit itself and thereby committed a jurisdictional error. In copper engineering case, the issue of jurisdictional error was not the issue. The issue was
Mr. Datta, where is the judgment of this court? Single judge's judgment
Yes.
on the point, where is it?
Pratapgarh case. Herein also, my lord, the basing upon the copper engineering case.
There is another judgment authored by one of us, myself. Where is that judgment?
Lordship, I cannot.
Search it out.
पता ही नहीं चलेगा। They are not aware of it.
You have challenged this, order, decision of the industrial tribunal?
Lordship,
Industrial tribunal's decision is at page
at page, Lordship will find 283.
283.
Lordship.
The operative portion.
Now, before that, my lordship submit one thing. That the Supreme Court in a Sure Enamel Stamping Works Limited in 1963 has settled down that there are the 5 parameters. That is the parameter of deciding the domestic inquiry. Now, the learned tribunal has not even discussed any of the point and travel beyond.
You just want that, what is the impugned order by which you are agreed and filed the.
Yes,
petition?
Lord. In a very short, Lord, you will find that first, Lord, you will kindly come to page 305. The learned tribunal said that the
305.
305, my lord, at the bottom.
Yes.
The learned tribunal says that we have the inquiry officer did not maintain the order sheet.
Sir, read which para, 305, which para you are
Lordship,
referring?
305. Lordship, kindly come to bottom. 305.
Yes.
In the case in hand, I found that the inquiry officer passed recorded the day-to-day order in all deposition sheet wherein the statement or witness is recorded in both parties. In absence of proper order sheet, it is difficult to know the important events occurring during the proceeding. Thus, I am of the view that the inquiry officer has violated the procedure rules.
Fine.
This is one of the findings.
One of the findings, yes.
Next, Lordship will find at 306.
Yes.
Secondly, it is seen that the inquiry 307,
307.
306 and 307. 306, last part.
Another petition.
Another petition, workman Nobo Gogoi allowing other 3 workmen for allowing them to represent by Nogen Chutia, President of Hindustan Unilever Workers Union. This petition was rejected by the inquiry officer based upon the report of the Superintendent of Police Tinshukia, such and such. Submission brought forward the presiding officer, such and such. The inquiry officer opined in his order that Nogen Chutia is not a co-employee, but an outsider. If Nogen Chutia is allowed to enter into the factory area, problem of law and order of factory premises would come because, as per the police report, Nogen Chutia was the leader of the agitators for which such situation was created, and the domestic inquiry is related to that incident. Thereon, the pretext of representing the charge-sheeted workmen before inquiry, there is every possibility of belief that there would be an outbreak of chaos and indiscipline in the factory premises. It is seen that the inquiry is a practicing lawyer in the Honorable Calcutta High Court. He permitted the management to conduct the case by engaging 3 executives of the management, such and such, as presenting officer from time to time. The record of proceeding of the inquiry does not reveal any specific order passed by the inquiry officer regarding the authority given to those 3 officers by him or any official letter issued by the management to them for conducting the inquiry as presenting officer on behalf of the management. On the other, the workmen are not so much qualified, even they may not be graduate. They are also not expert in dealing with the matters like domestic inquiry, as there is no record of established that they are otherwise trained persons. The charges against the workman is so serious as to entail a dismissal from the service. The inquiry authority should permit the assistance of a lawyer. When the case against the employee is handling by most qualified prosecutor, it is good ground for permitting the employees to engage a legal practitioner. The refusal to be represented by legal practitioner in such a case violates the rules and result in serious prejudice. In the case in hand, considering the seriousness of the charges leveled against the workman, the inquiry officer ought to give permission to engage a lawyer to defend their case. This is a decision has to be. Next, Lordship will find at page 309. Name and designation of translator not disclosed. Second paragraph.
Mr. Datta, the tribunal decided the preliminary issue holding that the domestic inquiry was not proper.
Now, my lord, my respectful submission is that Suriname case, Lordship is aware that only the 5 parameters are to be decided. Number one, whether the workmen are explain the charges or not. Second, whether the evidence was recorded in the presence of the employee or not. Third is whether they are giving an opportunity to cross-examine, and whether they use evidence, and whether the inquiry officer finding is based upon the reason or not. That the 5 parameters on the Suriname say, latter of which is also enunciated by the Supreme in other cases. Now, beyond that, the learned tribunal has traveled, touching upon the charges, saying that the charges are serious, saying that the charge sheet is written in bold letter.
These are all tentative findings. It is only a preliminary issue.
No, therefore, Lordship, the issue is that if the learned tribunal exceeded its jurisdiction, then only I have a case.
We'll make it clear.
Then only I have a case. Calcutta High Court Division Bench recently said that the corpus not applicable. Corpus not applicable. That is only my case, Your Lordship. That if the learned tribunal exceeds its jurisdiction,
We'll clarify it, that while deciding this, whatever the inquiry, this will not be influenced by any observation.
my matter is, my Lordship, my respectful submission is, this matter is in fact as a matter of remand, because the learned tribunal while deciding the inquiry did not touch upon those 5 parameters. So on the basis of Suriname case, let the tribunal take a fair decision. This is my only case. It is a case of remand.
Who's appearing?
Well, I am appearing for number 3 to 7 SKPW. What is the case?
Do you want to file any counter affidavit here?
Lord, my affidavit in the petition it will do, but only thing is that what I would like to submit, Lord, I may be allowed. The reference to 2014, since 2017 it is pending. In Cooper Engineering's case, Honorable Supreme Court has categorically stated that for
When is the next date fixed before the tribunal?
next date is 11th of September. So for
Let the matter be decided, my lord. We are not delay a single day.
because from Ludbud Singh onwards, my lord,
Issue the notices to the other respondents, we will decide it before say 11th of September.
Lordship.
from
On
Ludbud
5th,
Singh
Lordship
onwards,
may
my lord, from Ludbud Singh's onward, Honorable Supreme Court has held that if
So we are
domestic
supposed
inquiry,
to, if we want to confirm or interfere with the order of the learned single judges, notices are to be issued to the other parties.
my lord,
Notices are required to be issued to the other parties.
No, state is there and I am for remaining.
Who is appearing for the state?
1, 2, and 3 are state. And remaining are-
And 2 is presiding officer, I think.
Okay, presiding, what about 3?
3 to 7 I am appearing.
3 to 7 you are
3 to
appearing.
7 I am appearing.
President General Secretary Hindustan Workers Union. Okay. Okay. Issue notice. Ms. Arbi Bora is appearing on behalf of the respondent number 1.
1, 2, and 3.
Who is the formal party? Hence, no need to issue notices to the respondent number 2. Mr. So-and-so put in appearance on behalf of the respondent number 3. Services therefore complete. List this writ appeal for admission on 3rd of September.
On fifth, Lordship kindly on
Fifth.
fifth.
Okay, 5th of September.
You are appearing for only 3.
No, 3 to 7.
3 to 7.
3 to 7.
I is there, Lordship.
Well, consider it, sir.
Lordship,
On 3rd of September.
Yes.
On 5th.
grateful, Lordship.
5th September.
5th of September.
For hearing, item 37 to 41.
What?
My lord, the state has filed an affidavit. We have filed and reply also. My lord, my humble submission would be under the rules, state has no role once APSC takes a stand. If the lordship kindly permits me, I'd like to read one paragraph from my reply affidavit, then I'll place the rules, my lord. If your lordship would kindly come to page number 456.
It will about this.
Which petition, sir?
Lord, it's our latest reply to the affidavit filed by the
Which-
state.
which petition you have filed?
361, my lord. Read appeal 361. Lord, factual, briefly, we have stated in para 2, but I will not trouble your lordship in
Page
para
number,
2.
Excuse me, page number, sir?
361 of 23, read appeal.
No, page number.
453, my lord.
450.
It starts at 453. Lordship will kindly come to page 456. This subpara of para 3.
Yes.
Further, even on merit, objections raised by the state respondent in the paragraph under reply are perverse and beyond ambit of his jurisdiction. In this regard, it be stated herein that Public Service Commission in the country are framed under Article 315 of the Constitution of India, and state commissions are high constitutional bodies with their own autonomy. Article 320 of the Constitution of India emphasizes the functions of the Public Service Commission, which is interior to conduct examination for appointments to the services of the Union and the states. Assam Public Service Commission, being a constitutional autonomous body, is responsible for conducting examinations for appointment to the state services. Assam Public Service Commission CC Rule 89 inter alia provides that it is the commission which should recommend candidate for appointment to the service. Said rule further provide that appointment to various services is to be governed by the respective service rule. In the instant case, APSC, which is responsible for selecting the candidates, had not made any objection against the recruitment of the appellant. In fact, it has been stated that candidates in question have cleared the mains and subsequent viva voce examination on their own merit, and had also stated that preliminary examination is only a screening process. Further, since 1989 rule provides that appointment to various services would be governed by the respective service rule, it has become incumbent to appreciate the various service rule for which APSC conduct the CCE. For the sake of brevity, ACS rule 1998 may be taken as an illustration. Rule 5 of the 98 rule provides for method of recruitment, which entirely provides that direct recruitments may be made by the APSC to competitive examination. Rule 6 further clearly provides that a direct recruitment shall be made on the basis of recommendation of the EPSC. The state respondent, in terms of 1998 rules, pursuant to the recommendation made by the APSC, are only required to check whether such recommended candidate possesses requisite physical fitness and has an unblemished career antecedent. Therefore, it is apparent that once APSC makes its recommendation, state respondents cannot raise any objection with regard to the recommendation made by the APSC.
Not like that.
My lord, when the writ petition was pending, at no point of time, the state government came up with any such plea. And I'm not saying, end of the day, my lord, without making it a precedent, I think these cases can be considered, my lord. I think the state government's perspective could be such an approach may lead to some.
We understand that. And some law on this aspect, so you can consider this as some law, authority.
Okay, my lord.
Some authority, some judgment.
My lord, we have, or should we furnish a written argument along with the case laws, my lord? Or Lordship may keep it next week, my lord. Next Monday, my lord, we'll come up with some case laws. Some cases. Or could it be next Wednesday, my lord? 24th, my lord, if it is not inconvenient. Oh, sorry.
24th.
It's a holiday.
29th.
My lord.
29th. 29th August.
Item 48.
Yes.
48.
May it please the lord.
May it please the lordship. Lordship, before my esteemed senior starts, I would like to express my difficulty in this matter. I'm appearing on behalf of my senior, who is representing the respondent number 5, lordship. We have a little difficulty today. Lordship, could it be fixed on some other date?
My lord, I am not objecting on principle. What I'm trying to say is, my lord, our allegation was in the, just 2 minutes time, my lord. This particular contract was terminated and it was given to Mr. X, the private respondent. Now, our allegation was the termination was also illegal, and on the eve of his retirement, the respondent number 5, by flouting all the norms, gave the contract to respondent number 6. Now, my lord, based on some observation made by the learned single judge, now the authority has instituted inquiry. Now, as a result, my learned friend's client, he has been charge sheeted not only in the criminal case, he's also facing departmental proceeding. So, my lord, today I don't have any grievance because law will take its own course. But my only perspective is, my lord, this work should be given to me. I think we had spoken to the government, says since the matter is pending before the High Court, it is difficult for us. So if your lordships can make some observation, my lord, that pendency shall not be a bar. In that case, my lord, government may also take a call.
Pass it over for day only. It will remain on the board, pass it over for the day.
Yes.
Lordship, would a date be fixed after 20th, Lordship?
After?
20th. Just for a week, Lordship, just after 20th.
20.
20.
Can it be on 24th, my lord? Oh, sorry, 24th is a holiday, I'm sorry. It can be on 23rd, my lord.
No, 23rd is only 27th.
Holiday.
23rd is also holiday.
Oh, I'm sorry.
27th.
27?
My lord.
Much obliged.
Normally in this part of the country, my lord, once September 17 comes, the season also becomes better and the holiday mood starts, starting with Vishwakarma Puja.
Pass over matter 26.
I'm sorry, my lord, I was not. This is a dispute, my lord, between two wives, first wife and second wife regarding pension. So the fact of the case is the second wife came up before this honorable court via a writ petition with a prayer for releasing pension in her favor. The learned single judge passed an order. I am aggrieved by a portion of the order passed by the learned single judge, which is available at page 94, by which a direction was given to the pension department to determine and release pension. Paragraph 6, my lord.
Then thereafter they undertook some exercise.
Yes, they have taken some exercise and they have submitted on the last occasion that they are in a position to release pension in favor of the first wife, who is the legally married wife. And
That is, that is the appellant.
yes.
Yeah.
And the appellant will submit an indemnity bond before the pension department as per the rule. Will share the pension with the second wife's child.
Now what remains?
This is but I'm just challenging the direction given by the
That has already been complied with.
Yes.
That direction has already been complied with by the department.
Yes.
The learned single judge has simply said, okay, decide what are the quantum of this pension is required to be paid to the unmarried daughter of the deceased.
Yes.
And now that they have carried out and they have passed this order, what remains there?
Yeah, this will do, my lord. If they have agreed to, my lord, release pension, my lord, pension department.
Department itself has issued this order. Yes. Who is appealing for the pension department? Yeah.
Lordship, if both them agreed, your lordship, we can.
Yeah.
Bone no, bone no, here provision as well. In every case, the family pension recipient has to sign and submit an indemnity bond. Department of the
Lordship, as per instruction, Lordship, we have issued to the Treasury officer on 10/6/24.
That is Accountant General Office.
Accountant General Office. Lordship.
And what
Now,
about the Treasury Officer? What he has done now? Yes,
Treasury officer.
yes, Mr.
No action has been taken, only the letter was issued.
Who is appearing for the Treasury Officer? Who is appearing for the Treasury Officer?
Financially appear, Your Lord.
Call him. And who is appearing for the private respondent?
My lord, I am appealing.
Yeah, do you have any objection regarding that?
My lord, the thing is that I have not receiving, my lord, any instruction, my lord,
Any
from
instruction?
the Treasury office, my lord.
You are not supposed to get any instructions. The respondent, the appellant is required to get any, whatever the instructions are.
My lord, he, my lord, filed before the bond, before the Treasury office, my lord.
That is the order.
And in the earlier occasion, my lord, he received the GPF amount, my lord. No share has been paid, my lord. That's why I compelled to approach before this honorable court, my lord.
Whatever it may be, but since now this order is already there, the treasury officer is required to release the pension amount or whatever it may be in favor of her. Let him wait for him next call.
Item 28.
As directed, my lord, the authority has filed an affidavit. And that proves that it was not even a disability. It was, it is more an ailment, curable ailment.
Lordship, that is what we have found after reassessment, Lordship. I filed the affidavit on Friday, Lordship, but it is not on record, Lordship.
But after this examination report, what remains in the matter?
Lordship, from our point, Lordship, there is nothing, Lordship.
It's not a permanent disability.
Yes, Lordship, that's why we cannot issue the certificate, Lordship.
In fact, what they have specifically said in the affidavit is it's a ailment which can be cured. And in the meantime, without even having undergone any treatment, there is already an improvement from 55% to 51%.
You have already filed that?
Yes, Lordship. On 9th, Lordship, it was filed.
Pass over for the day. In between, you just get the.
The interim.
On behalf of respondent number 2.
Bring it in record. They have to come up.
Can it be next Monday? This entire week I have to be in Arunachal.
Next.
Yes, 19.
Highly obliged.
The
Interim order is continue till next week.
obliged.
Highly obliged.
Item 36.
Done present. 6 weeks.
Item 26.
Yes, who is for the finance department? Who is appearing for the finance? Who used to appear for the finance? Who used to appear?
नाम दिखा के एक चलिए ऐसी फाइनल।
Leave this matter tomorrow while reflecting the name of Mr.
Chalia.
Chalia for respondent for the finance department, counsel for the finance department.
Please inform him.
Inform.
Oblige. We'll like to dispose it of.
Much obliged.